So, dear friends, good afternoon. There will be a very short session, which in fact is reporting from the two parallel sessions, so that information about what has happened circulates amongst all the participants to the conference. I hope you have enjoyed the two parallel sessions, and now it's time for me to give the floor to the moderator of the first parallel session, which was held in this great hall, Mr. Professor Dalibor Jílek, whom I now give the floor.
Thank you, Vít. Yeah, I have already mentioned that the topic of this panel looks like a triangle. The first point is about the concept of the child's best interest. Second point, this is identification of procedure. And the third point is about guardianship. What about the first point? This is necessary to say that this is the legal concept. This is not only a legal concept, this is also the complex concept, and this concept plays three different roles, not only at international level as well as national level and also in the local level. The first role is substantive. It means that each child has the right to the best interest as a primary consideration. The second point is about, and the role is about interpretation. If we have two interpretation of the provision of the Convention of the Right Child, this best interest serves as a collision rule. It means that we have to make a choice between two interpretations of the provision, and we should be in favor of the interpretation which is very close to the best interest of the child. Third point is, this is about procedural role. And I would say that from the theology, that the purpose of the concept is aimed at ensuring both the full and effective enjoyment of all the rights recognized in the Convention. That in this respect, I mean that the best interest serves for enjoyment, all the rights of the child, and also the holistic development, which is anchored in Article 6 of the Convention. This is the complex. Substantive right, interpretation principle, and the third point, this is a procedural rule. And this procedural rule must be respected in identification procedures. We differentiate between two procedures, screening and assessment. And in both, the screening assessment procedure, the principle of the best interest of the child must be respected and presented. Yeah. It is also a very complex process, sometimes requires a multidisciplinary or interdisciplinary approach of the organ. From the point of view of the Convention on the Rights of the Child, Article 8 gives the child the right to preserve his or her identity, and the competent authority should introduce the procedure which is child-sensitive and child-friendly. We also discuss age assessment issue. This is also a complex issue because many state authorities rely on medical examination the question of the ossification of the wrist or mineralization of the teeth. But on the other hand, the question is about the method which are applied in this process of age of the assessment. Yeah, because sometimes this is not very easy. Yes, because the medical examination only set up not chronological age, but estimated age, and the question is about objectivity and the reliability. Yeah, I'm sorry. And we only applied this age assessment in the case of reasonable doubts, and it is necessary to take a multidisciplinary evaluation of independent authority, and also the assessment decision should be subject to administrative or judicial appeal. Maybe it is to this question of age assessment. Third point about guardianship. We studied some principles for the guardianship. The first principle is that it's necessary to promptly appoint the guardians for the child in migration or asylum situation. And the second principle, that we should differentiate between the legal representation, legal aid, and this guardianship. Yes, because the guardianship gives and helps, gives the child a voice and helps the child, yes, in this very vulnerable situation. We know that the guardians should be competent people, and this is not very easy task to train those people as guardians, yes, because they will be qualified in legal terms, in social issues, in psychological terms, and therefore those people should be very carefully trained. There is also the problem with third principle, which is also very important, and this is the issue of the burden, yeah, because sometimes the guardians are overloaded, yes, how many children they have, and perhaps this is the point which should be taken into account. Other principles is about dependency, independency. Yes, because those people should be independent on the staff of the reception center, also independent and other state authorities. And the question is about, yes, because we analyzed the situation in Greece. What about the state prosecutor or temporary prosecutor and his role as a guardian? Sometimes this is necessary to create a specific system. Other points is also that the system of guardianships are very, very different because we differentiate between the centralized and decentralized system, also between the professional and volunteer system. The question is about the engagement of NGOs in providing guardianship to the child in asylum and migration situation. And we also put the emphasis about the participatory approach. It means that there will be the friendly communication between the guardian and the child. Yes, because the participation is covered by Article 12 of DG of the Convention on the Rights of the Child, and a child must be communicating in each stage of proceedings. Yeah, this is certified. Maybe this is the basic summary of mine. Thank you.
Perfect. Thank you very much indeed. And now I would give the floor to Stavros, so that he gives us a summary of the discussions in the other parallel session, which was held in the small hall. Please, Stephanos.
So, thank you very much, and thank you for the excellent organization of this conference. First of all, I would like to explain that the gap between us has nothing to do with the gap between Strasbourg and the Czech Republic. It's rather the Czech Republic and Greece that are far apart. But we had a very interesting session on vulnerability, and this is a concept that gains a lot of currency in the United Nations today, in the run-up to the Global Compact. The two global compacts, the United Nations aspire to provide us with a set of guidelines on migrants and refugees in vulnerable situations. And the way that vulnerability is defined in the United Nations is situational. It has to do with the situation in which you find yourself rather than who you are. But in the case that we are dealing with here today, we have a very vulnerable group defined by their personal characteristic, children who find themselves in a situation of additional vulnerability because of detention. So, how do we deal with this? We have had two very helpful explanations, one coming from a psychologist and another one from a lawyer from the European Court of Human Rights, and also a very lively discussion which was expertly summarized by the organizers, who provided me with a full draft of what transpired during the discussion, which was extremely helpful, and it's the first time that we get so much help. So, what did we discuss? Some participants felt that it was not right to always be so negative what states should not be doing, but rather to invite states to think about how welcoming we should be vis-à-vis migrant children and making them feel psychologically comfortable. Of course, this is a very good approach. However, governments have to take also other considerations into account. And this is why we also have the international standards that provide guidance in this respect, how far governments can go. Of course, we have the European Convention on Human Rights. We have lots of other procedures, Council of Europe procedures, and other international procedures. We were helpfully reminded of the fact that the Convention, the case law of the court, and the other procedures only indicate the floor. So, what you cannot go below. Quite often, we must seek to go above what the Convention protects and what the Court tells us. We must be looking for good practices, and this is an arena, this is a forum where good practices can be usefully exchanged. Having made these introductory remarks, now, the two specialists. The first specialist was a psychologist. She explained to us in very colorful terms the damage that happens to children in detention. And damage happens to unaccompanied minors, but also damage happens to children that arrive here in Europe together with their families. And quite often the damage that happens to children has to do with the ability of the family to cope with detention and migration. And many families, unfortunately, cannot cope, and this has very seriously damaging effects on the children also. These effects can be psychological, but also can be developmental effects, whether once you exit detention, you will be a fully grown individual. And the psychologist explained to us that the developmental harm is quite often irremediable. And to use an example, education, the CPT, and there I rectify some comments that I made during the panel, and the Special Representative of the Secretary General on Migration and Refugees are both very skeptical as to whether there can be meaningful educational activities in places of detention. So the conclusion was that there is no way that detention cannot harm children. It will always harm children. The only thing that the psychologists can do is to try to mitigate the harmful effects of detention. Children are vulnerable per se. They leave detention always in a more vulnerable condition. And replying to the questions from the floor, it was clear that there is much more harm done to children in detention than those who are accommodated in open centers, and also that detention that has to do with migration, it's much more harmful than detention that is done for educational purposes, because the children that have migrated carry the baggage of migration with them. Then we discussed how the psychological evidence can be used in litigation before the European Court of Human Rights. And the Court of Human Rights quite often uses evidence from psychologists. Quite often it does not consider it necessary to use such evidence. It relies very much on what it knows already about the damaging effects. But one thing that we must bear in mind is that when we ask for provisional relief, when we ask for interim measures, then it is almost indispensable to produce a medical certificate, because the court is unlikely to grant interim relief if it doesn't have the evidence before it immediately, because the court has a rather strict policy on granting interim relief or not. Then the case law of the court, of course, it is clear. How do you determine whether somebody is subjected to inhuman or degrading treatment? You have to take into consideration their personal circumstances. In the migration context, the court is going to look carefully into the history of the individual, the history of migration. And also what was quite revealing to me is that probably the court will not attach a lot of importance to the legal status of the individual. It will not make a lot of a difference for the court whether the person in detention, the child in detention, is an asylum seeker or an irregular migrant. What the court is going to look at is the difference between a child and an adult. So even in cases having to do with post-traumatic stress disorder, the court is likely to be more lenient vis-à-vis adults who are detained, and a lot stricter when children who are confronted with this condition are put into detention. And also, what transpired from the discussion is that although the court attaches importance to the duration of the detention, this is not a determining factor. The fact that detention can be of a short duration does not mean that there is no violation, because you have to look at all sorts of other parameters, including, of course, whether the authorities have looked for alternatives to detention. So the trend is quite clear. The court has found a violation in every single case having to do with children in migration detention. So this is the trend. Although our colleague from the court, repeating what Anne said this morning, the former judge from Ireland said this morning, although it is unlikely that the court will say that migration detention for children is always illegal, there's a clear trend in the case law pointing in the direction of violation. So I think this is the most safe conclusion that we can reach from our panel, that the trend in favor of violation is there in the court's case law. Harm is there. There is always harm when children are put in migration detention, and we should not care so much about the conditions of detention. The harm quite often comes from the fact that children are deprived of their liberty per se. And I think this is a very good conclusion coming from the panel. Thank you very much.